Why do so many attorneys, defense attorneys especially, give preliminary instructions to my client when they give pretrial testimony in a question and answer session known as a deposition? You want to know the answer? Come join me as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. A pretrial question and answer session known as a deposition, it's also known as an examination before trial, takes place in an attorney's office. And there's a court reporter there to take down all the questions and all the answers that are given. But what I find fascinating, I've been doing this now more than 26 years, in almost every instance where the defense attorney is in our office questioning my client, they spend 5 minutes giving my client preliminary instructions. Now what does that mean? Okay, Mrs. Jones, I want you to know that when you answer questions, you have to give a verbal response. Okay. You can't just nod your head or go, mm-hmm. Okay, that's fine. If you don't know an answer, tell me you don't know and I'll ask another question. Okay, isn't that common sense? And they give a whole series of preliminary instructions. And why do they do that? One of the key reasons why these defense attorneys go ahead and give these lengthy preliminary instructions is so that if my client later on at trial now says, hey, I didn't really understand what you were doing during this question and answer session in my attorney's office, they'll go back to the first few pages and say, wait a second, I told you that this is what is going on. This is what you agreed to, and you recognized that you would go ahead and agree and acknowledge this. Isn't that true? Yes, it is. The whole purpose of that is simply if there's confusion on the part of my client, to go back and say, hey, I gave you these preliminary instructions, and here's what to do if you didn't know how to answer the question, or if you didn't understand my question. And you can't just go, mm-hmm, yeah, okay, because the court reporter can't take down that information. They can only take down something that's verbal. You want to know why I rarely, if ever, give preliminary instructions when I'm questioning a witness during their pretrial testimony? It's because they have already spent at least half an hour, an hour and a half or more with their attorney preparing them for the questions that I'm about to ask them. It's known as a prep session. And the whole purpose of that is so that the attorney can now discuss with their witness what the questions are likely going to be, how to answer the questions, what to do if you don't know what happens. So now I don't need to do that. Instead, my goal and my agenda is to go right to the heart of the issue. Mr. Jones, tell me why you went through the red light. Doctor, tell us why you took off the wrong leg. Doctor, why did you operate on the wrong side of the brain? I want to know immediately what the key issue in the case is. I want to know why they did something. And this gives me a clear opportunity. The instructions, the defense attorney already gave those instructions. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in a medical malpractice case, in an accident case, in a wrongful death case, where now we have an opportunity to question the witnesses that are involved. You know, I realize you're watching this because you likely have questions or concerns about your own particular matter. Well, if your matter did happen here in the state of New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.